That Nnamdi Kanu informed the court few days ago that he's going to enter his defense by himself, and so he did away with his lawyers. Kanu Agabi, Onyechi Ikpeazu, all of them senior advocates of Nigeria. He said he doesn't want them anymore. And then the court asked him how he wanted to proceed, and he told the court that he wants to do his defense by himself. The matter was adjourned for him to do that. And when the court session resumed, Nnamdi Kanu informed the court that he is not going to proceed with his defense. And the judge did say that Nnamdi should file written address. In this video, I explain what that means. What's the legal implication of Nnamdi Kanu's decision not to call defense? Okay, what did the judge mean by asking him to file written address? Okay, what are the legal issues around this? Okay, these and many more are the things I'm explaining in this video. Now let's see what transpired. This is the report. The report says, at the resumed hearing today, that's yesterday, Mazi Nnamdi Kanu said that the court, okay, he said to the court that he has gone through the case file and has realized that there is no valid charge against him. That was Nnamdi Kanu informing the court. That he has opened the files, one after the other, everything filed. The charge proffered against him by the prosecution. He has looked through the evidence, and he has come to the irresistible conclusion that there is no valid charge against him. He went on. He argued that since he is convinced, personally convinced, that there is no valid charge against him and that he was subjected to unlawful trial, note, unlawful trial, there would not be need for him to open his defense. That's what Nnamdi Kanu told the court. He has gone through the case file. He has seen that there is no valid charge against him. And that since he has gone through the file, he has seen that his trial was unlawful, he doesn't want to enter his defense. There's nothing to defend, according to Nnamdi Kanu.
Now, I believe that why Nnamdi Kanu doesn't want to go into trial in this case is because the judge does not have jurisdiction to try him. Why? Because we all remember that he was extraordinary rendition from Kenya. And once you extraordinary rendition anyone illegally, that means, you have lost the right to try that person. Remember that appeal court has ruled in his favor in that case. Even we all remember High Court of Aba has ruled in his favor that they do not have the jurisdiction to try him, that because of the extraordinary rendition, they should send him back to Kenya where they brought him from. Still, they said no, that they must try him. Remember that Nigeria has broken both national and international law. Once you extraordinary rendition someone without due process, without legal processes for you to bring in the person, you have lost that right to try the person. I don't know why they are insisting that they must try him, even when their own court, two courts, has already discharged and acquitted him. Now, assuming that he goes into this trial and he was found guilty, and sentenced, won't the federal government obey that court order? Of course they will obey it. But now that two court has already ruled in his favor that he should be let go, they said no, they refused to obey the court order. Is that how countries, is that how country grows? When there is a court order against the government, they will not obey it. But when it's in their favor, they obey it. My people, is that how a nation, a country grows? Saba. Let's finish listening to this guy.
The report then says, Justice Omotosho, that's the presiding judge, asked him to file a written address to that effect and to serve a copy of it on the prosecution, which is the normal thing to do in law, right? When you file, you serve it on the other party because it must be on notice so that the other party can also respond. The judge advised him to consult experts in criminal law on the consequences of the option he has chosen. The judge took out time to talk yesterday in court that he should consult legal experts in criminal law to brief him about the consequences of the option He has chosen. What is the option? Not to defend. Because Nnamdi says there is no valid charge against him. The judge thereafter adjourned the matter till 4, 5, 6 November. That's a few days from now, right? This is October ending, for the adoption of the final written address. That means the judge has given him less than 2 weeks, less than 14 days, or less than 10 days or thereabout, to file the final written address based on the defendant's position that evidence led so far and the charge have not established any case against him. Right? Now, this is Nnamdi Kanu, okay? We asked some questions. What is the legal implication of what transpired in courts yesterday? What is the legal implication? The answer is that, one, it means that Nnamdi Kanu has closed his defense and has formally informed the courts about it. When the prosecution opens his case and closes it, calls witnesses, tenders documents, the next thing that follows is for the accused person to also do the same thing that the prosecution did. Call witnesses, testify in your favor, tender documents to tear down the case of the prosecution, right? But in this case, Nnamdi says he has closed his defense and he has formally informed the court that he doesn't have any defense to give to the courts. Number two, it means that Nnamdi has chosen not to speak in his defense. He has chosen not to speak in his defense. Right? Is that a good decision to take? We continue. 3, he has also chosen not to call witnesses to speak in his defense. Nnamdi had listed a number of witnesses. Nyesom Wike was one of them. The former Attorney General during Buhari's administration was there. And a number of other witnesses, I think 8 or 9 high-profile witnesses, and Nigerians were expecting to hear from them how they are going to testify in Nnamdi Kanu's defense. What happened yesterday means that Nnamdi has informed the court that he's not calling any of those witnesses anymore to speak in his defense. 4, so it means that the court has taken his case to be voluntarily closed by him. That's the consequence, that's the implication of what transpired in court. Nnamdi has closed his case. He's not calling witnesses. He's not also talking in his defense. That's the implication of it. Now, what then happens when a defendant informs the court that he has nothing more to say? Nothing at all to say. What happens? The answer is this. 1, the court will tell the person to file his written address. This is what the judge did in his case yesterday. 2, when the address is filed, Nnamdi will be expected to serve a copy of it on the prosecution. The written address should be a summary of the arguments, stroke points of law, and decided authorities in support of Nnamdi Kanu's case. Okay? Now, 3, when he serves his address on the prosecution is expected to also file its final address and serve it on Nnamdi Kanu. Nnamdi will then be expected to file a reply address and serve it on the prosecution. So Nnamdi is going to file 2 addresses, while the prosecution is going to file 1 address. 3 addresses are usually filed. Nnamdi will file the first one, the prosecution will reply, and after that, Nnamdi will file the second and the last address in the matter, right? That will mark the end of the proceedings in the matter. Once the 3 addresses are filed, it will mark the end of the proceedings in the matter. A date will then be fixed for judgment, right? A date will then be fixed for judgment. Now, there are some concerns at this point about this matter, the way the matter is going. There are some concerns, and this is pure issue of law, right? I hope you understand it that way. Number 1, legal submissions are tailored submissions. You are not allowed to say everything you would have loved to or everything that happened. You just tailor it to the facts in issue. You tailor it to what the prosecution has presented against you in the court. The prosecution has said this and that, so you just go straight to those points and show the court why the prosecution's case should not be accepted. And then you have decided authorities to support your position. It is tailored. It is measured. Okay? They are guided submissions and must be supported by law and decided cases. This can better be done by legal experts. And that maybe explains why the judge, who is himself an expert in law, told him to seek the advice of legal experts, right? Now, if you are not trained in law, I tell you, it might be very difficult, if not impossible, to make the legal submissions needed to defend anyone in court. It's like in medicine. If you're not trained in medicine, it might be difficult for you to carry out an operation. What the defense lawyer does in court is similar to an operation. And for you to successfully carry out an operation in medicine, you must be a trained medical expert. So, one major concern in this matter is the fact that Nnamdi is not a lawyer. And so, having chosen to do all of this by himself, it is a bit concerning. But at the same time, the law allows him to do it by himself. And if Nnamdi believes that he can do it successfully on his own without the services of his lawyer, that's fine. He goes ahead to write the final written address, cite the written authorities, and then submit it to the court. The court will take, the court will read. But note that this is a hurdle on its own. The writing of final written address, it's a hurdle on its own in the field of law. Number two, this is another concerning issue. The challenge in this case is that this very court dismissed the no-case submission that was made by Kanu Agabi, senior advocate of Nigeria, and other senior advocates for Nnamdi.
Now, based on this analysis, what do you think? Do you think that Nnamdi Kanu should enter the trial or not? And remember, immediately after written address, is being adopted, the next is judgment, which take place within 3 months. What do you think? Remember, legally, the federal government does not have the jurisdiction to try Nnamdi Kanu because of the law they have broken by extraordinary rendition him back to Nigeria without due process. That is the law they have broken. They have lost that right. Try him. What do you think? So do you think that Nnamdi Kanu should go into this trial or not?